So this is going to be my last video on Mental Hygiene Law Article 10, I believe for it. Okay, so 10.03. In Mental Hygiene Law, the word commissioner means the Commissioner of Mental Health or the Commissioner for the people with developmental disabilities. Now, I actually looked up who the hell these people are because it would be less confusing for me. So the one for mental health is a medical doctor. It's Anne Sullivan, MD. Okay, and then the one for developmental disabilities, that's Delaney. So it's those two that they're talking about in this article, not the Commissioner of Corrections, Anthony somebody. Oh yeah, Delaney, Carrie Delaney. So it's Anne Sullivan, MD, and Carrie Delaney. Those two. If either of those two, they have to provide the respondent and counsel for the respondent an annual written notice. All right, so we have Anne Sullivan, MD, and Delaney. 10.03. A person who is a detained sex offender suffering from a mental abnormality, having such a strong disposition to commit sex offenses and such an inability to control the behavior that that person is likely to be a danger to others and commit sex offenses if they're not confined to a secure treatment facility, is a dangerous sex offender requiring confinement. That's the definition of it. A commissioner shall establish a case review team consisting of at least 15 members and any 3 of them. Okay. Oh shit. The commissioner, which in this case they're talking about Anne Sullivan, Commissioner of Mental Health, Anne Sullivan shall establish a case review panel consisting of at least 15 members. And it's at least 15 members. It could be like 25, you know. Any 3 of them may sit as a team to review a particular case. Now that makes sense because if 2 of them want to send it to the Attorney General, you want to have an odd number. So this way, either 2 of them want to do it and 1 of them doesn't, you're not going to get like a tie. When it appears to an agency having jurisdiction that a person may be a detained sex offender is nearing an anticipated release date from confinement, the agency shall give notice to the Attorney General and Anne Sullivan, MD, Commissioner of Mental Health. Where a case has been referred to a case review team and it finds that the respondent is a sex offender requiring civil management, the case review team shall provide written notice to the Attorney General and the respondent within 45 days of Anne Sullivan, MD, receiving the notice of the anticipated release. Must include a written report from a psychiatric examiner that includes whether or not the respondent has a mental abnormality. Okay. Why is this I feel like maybe because I'm not drinking any water or anything, but it could be also I'm washing my face with hand soap and not brushing my hair because I can't be bothered to do any of that because I'm studying for this fucking test every waking moment that I'm not doing something else that I had to do. Okay. So again, what I was saying was, okay, so that other question I read about the agency with jurisdiction, person anticipating a release date, I think that had a 120-day rule in there, even though it was a soft 120-day rule. Let me just make sure. The referral is provided to the respondent. So that's something interesting to note. So when the person is referred to the case review team, those 3 people, the referral, notice of such referral shall be provided to the respondent. Yes, it is 120 days. So they shall strive, the agency with jurisdiction shall strive to give such notice at least 120 days before the release date. But if they don't, not a problem. Sex offender requiring civil management. Now remember, civil management could be either the confinement or the strict and intense supervision, where a case has been referred to a team and they find that they are a sex offender requiring civil management, the case review team shall provide written notice to the Attorney General and the respondent within 45 days of Anne Sullivan, MD, receiving the notice of anticipated release. And this must include a written report from a psychiatric examiner that includes whether or not the respondent has a mental abnormality. 7, within 10 days after the Attorney General files, so now he's filing, okay? He doesn't have to, he may file it, but in this case, this question is talking about he did file it. Files a sex offender civil management petition, the respondent within 10 days may file a notice of removal. Now, I went over this in like terrible detail in the other one, so I'm not going to belabor the point. It's 10 days after the filing of the petition, the respondent can file the notice of removal. The Attorney General can make a motion within 5 days after he gets served with the notice of removal. Next, within 30 days after the petition is filed, the Supreme Court or the county court shall conduct a hearing without a jury. It's the probable cause hearing here. So 30 days for the sex offender probable cause hearing. This is not looking for confinement versus super intense supervision. This is only a probable cause to believe that the respondent is a sex offender requiring civil management. Now, move on to 10.07. This is the within 60 days after the court determines there's probable cause, the court shall conduct a 12-person jury trial. And the issue for the jury is to determine whether the respondent is a detained sex offender who suffers from a mental abnormality. Now, that is the actual definition of a sex offender requiring civil management, right? But it's to make it clear that the court is going to decide whether or not he requires the civil management, if he needs the confinement or the strict and intense supervision. Note, during the trial, the respondent may not subpoena victims of their underlying sex offenses without leave of court. So, yeah, you have to get leave of court for that, and it's got to be on good cause. And I, again, in one of the other videos, like, beat the jury trial thing to death, so I'm not going to do it again. 10.07, subdivision D, which, if any of the following are true concerning the trial described in question 9. 1, a jury trial may be waived. Burden of proof is on Attorney General. Case must be proved by clear and convincing evidence. Jury's finding must be unanimous by all 12 jurors. At the trial, either party may request sealing of papers for good cause shown or closure of the courtroom. Now that is really interesting because we have open courtrooms in this state, okay? Public hearing. But it says, for good cause shown, either party, the Attorney General or the respondent, can request closure of the courtroom or sealing of papers. The Commissioner shall provide the respondent and his counsel with an annual notice of the right to petition the court for discharge. Okay, now, 10.09, this says the court shall hold an evidentiary hearing as to the retention of the respondent within 45 days if it appears from one of the annual notices that the respondent has not affirmatively waived the right to petition for discharge, okay? So let me make this very clear. There is no time rule in this. There's no time rule for the respondent, but it says for the court, within 45 days, they have to hold an evidentiary hearing, because when they send the notice to the respondent in the secure hospital or whatever, it's gonna have on it, on the thing, a notice that, like a waiver form, where he could fill it out, and if he's really not interested in getting out for some reason, or having a hearing, which he maybe figures he's gonna lose at the hearing, so he doesn't want to do it, he's gotta fill out that waiver thing and affirmatively waive the right to petition. And if he doesn't, then the court has to hold this hearing within 45 days. That either he did petition the court or has not affirmatively waived the right to petition. The Attorney General may, in the appellate division of the Supreme Court, oh my God, you know what? I don't care. The Attorney General may, in the appellate division of the Supreme Court, seek a stay of any order under this article, releasing a person. So if the court wants to release a person for some reason and the Attorney General is like, wait a minute, that guy's gonna go like rape a bunch of people, they can petition to the appellate division. Again, they petition, oh, well, it doesn't say petition, it just says seek a stay in the appellate division, which makes sense because like you're not gonna go to another, you know, they don't want to bother saying, oh, well, if it was county court, you could go to Supreme. No, just county court or Supreme, whichever judge it was, you're going to the appellate division. So if the county court judge releases the person, the Attorney General still goes to the appellate division. Both the Attorney General and the respondent may appeal. Now, this question, I did not like this question. This is number 15 on Mental Hygiene Law, Quiz 10. And I did not like this question, and I'll tell you why. Now, it's about talking about the appeal. So we're going to read this one from the statute directly. So I also want to say something about the evidentiary hearing, about the waiver, the annual thing. It also says that even if the respondent has waived the right to petition and the commissioner determines that he's still a dangerous sex offender requiring confinement, the court finds on the basis of the materials described in subdivision B that there is a substantial issue as to whether the evidentiary hearing on that issue as to whether there is a substantial issue as to whether the respondent actually remains a dangerous sex offender requiring confinement. Like maybe the guy's like 98 years old at this point. The Attorney General has the burden of proof if there's a hearing. If at any time the commissioner determines he's no longer a dangerous sex offender requiring confinement, then the commissioner shall petition the court for discharge or for the imposition of a regimen of strict and intensive supervision and treatment. The petition shall be served upon the Attorney General and the respondent and filed in the Supreme or County Court where the person is located.